A man, appearing disheveled and agitated, approaches the school grounds. His erratic behavior catches the attention of a few students and staff members. He begins shouting incoherently, causing visible distress among the children. A teacher notices the situation and immediately contacts the school administration.
Has a lot of work that needs to be done to, I don't know why you're giving me the attitude.
No, I'm not trying to. I'm sorry.
Yes, you are. Either that or it's because you're high. I don't know which one it is, but you're giving me attitude, and that attitude will most likely be readjusted by me at the Bexar County Jail. So I don't know if your attorney told you this, but I can send you to the Bexar County Jail as a condition of this probation, and I can also send you to the state jail facility as a condition of this probation for attitude readjustment. Do you want that?
Did you move in then, or what did you do?
I have issues when I go to his house. I can't go there. I have autoimmune issues.
I have also.
I wasn't talking to you.
Okay, that's nice.
You know what, young man? I'm going to tell you one thing right now, and I'm going to tell you, you better check yourself. So I'm going to give you a minute to go out into the hallway. Otherwise, what's going to end up happening is you're going to be in contempt. I was talking to Miss Cunningham. I wasn't addressing you. I don't know why you.
Inside the school, the principal receives the alert. Without hesitation, she activates the school's lockdown protocol. Classroom doors are locked, lights are turned off, and students are instructed to hide under desks. The teachers maintain calm, reassuring their students while keeping a watchful eye on the hallway.
Felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now. Right now. And when you feel like you can behave yourself, then you can come back in.
And I can't tell because it's not entered in the computer system. It's a felony case, and for whatever reason, the court has decided that we don't enter felony cases until the day of the hearing, I guess. I don't
Counsel, your sarcasm is not acceptable. And that is not, please don't interrupt me. And that is not what the court has decided to do.
At any time, intentionally, negligently.
Not intentionally, I was backing up.
I don't care. Stop, listen
Sorry.
to my question. Did you at any time, either intentionally, negligently, recklessly, in any way, shape, or form, damage their truck?
No.
Within minutes, police vehicles arrive at the scene. Officers swiftly disembark and head towards the school entrance. Their presence is commanding, and their focus is evident. They assess the situation, communicate with the school staff, and begin searching the premises for the individual.
So at no time, through any actions of yours, at no time did you damage their truck? It's easy, yes or no?
Can I explain?
No.
Sorry.
Yes or no?
No.
So you've never at any time did any type of conduct in any way, shape, or form that would have done any damage, a scrape, a nick, any type of damage to their truck? Yes or no?
See, sorry, it's hard for me to answer.
It is not. It's a yes or no.
Well, I'm not trying to lie, but
It sounds like you are.
no, because their son backed up. I was backing up and he cut me off. And so that's
Don't
when
care
I
about
bumped it. So
explanation.
that's why
Don't care about
I'm not,
explanation.
so then I guess, yes, I guess I'm not really sure because it wasn't intentional and that wasn't ever my main
Miss Mott, zip it.
And
The man is located near the school's perimeter. He appears increasingly agitated, gesturing wildly and shouting. Officers approach cautiously, attempting to de-escalate the situation. After a tense standoff, the man is subdued and taken into custody without further incident.
they live with their dad.
Okay, she's
In joint custody.
time out. You're being very dishonest and slippery with me because I asked you. My mind is a steel trap, but I wanted the court reporter to read back because maybe my mind is failing, but I highly doubt that. You told me that your children were living with you and their father, and you said the other father he's not a part of anything. Now you're telling me, oh no, he doesn't live with me. It's on and off. You've been dishonest with me from the very beginning. You were dishonest when I asked you if you're going to be positive. You were dishonest about that. Then you were dishonest about Bloodworth. I don't even know if this is this person's real name or not. Then you were dishonest about Sarabia. At first, and later you said he was the father of your children. Now he's not the father of your children. You're just being dishonest all across the board with the court, and I don't appreciate it.
Have to feel about it. But Ms. Bacon, you're
With the threat neutralized, the lockdown is lifted. Students are allowed to return to their classrooms, though the atmosphere remains tense. Parents begin arriving to pick up their children, expressing concern and relief. The school administration sends out notifications to parents, assuring them of their children's safety and outlining the steps taken during.
conduct in this case has been abhorrent. You have absconded over and over again. You've never complied with bond. You make excuses for it. Your response to the assessor, the way you responded to them as recently as 10 days ago. You say you got cleaner in the jail, but you were already in jail for a month when you saw her and you still acted the way you acted.
Together, and he can still have his complaint, I guess, that he has, and maybe if he'd listened to his attorneys, he won't have the complaint, but I'll let him do what he's gonna do. I'll adjourn it to June 22nd, 2023, 9 a.m. Motion, all right. See? Okay, why don't we do this? If he wants to play it that way, we'll just make both those hearings in person. Because if he wants to play that way, Mr. Brown, what do you want me to do with that?
Your Honor, I will leave this completely in the court's discretion.
The video begins with a serene morning at an elementary school. Children are seen entering the school gates, chatting and laughing. The sun casts a warm glow over the playground, creating an atmosphere of normalcy. However, this tranquility is about to be shattered.
Absolutely.
Okay, let's bring him up. I'll set that in person. That's at 2 p.m. on the 22nd, and we'll see how he wants to act that day. His request for withdrawal of counsel denied.
Prior to this one, I tried to work with them, but could you please stop? This is why I really just don't feel like I should work with them.
Just a minute. Mr. DeMayo?
Yes, Your Honor.
Sit down and pay attention. You're in a court proceeding. Don't get up and walk away because you didn't like something somebody said. You're asking for her grace to let you stay until the end of May, and then you act like that.
I'm sorry.
Otherwise, we can have a hearing and you can be out in 10 days and the sheriff will put your stuff out in the street. They allege your kids are dancing on the roof. They're breaking windows out. There are other allegations that have led them to.
With the trial type settled, the judge orders the discovery process to begin. Mr. Martin is granted access to the body cam footage through formal channels. The courtroom witnesses the judge balancing patience with authority, making clear that due process will be upheld without compromising the court structure.
Terminate the tenancy. You haven't paid the rent since September, and you're full of indignant disgust.
McKnight.
Oh, you know I'm pregnant. I can't do all that.
Miss McKnight, you got to stop getting pregnant, ma'am. I know that's not a thing that people supposed to say, but you keep bringing kids into this world and you can't take care of them. Please stop. It's like every year I see you, you got 2 kids. Miss McKnight, this is not fair to these babies. You keep having, what are we on, number 8 now?
No.
7?
Yeah.
Miss McKnight, you know you can have sex without having a baby, right?
Case sits right now.
Okay.
Don't interrupt me. We're going to have a way to, you know what? Tell you something, Mr. Montgomery.
Mr. Martin continues to question the proceedings, arguing that he's being forced into a fraudulent situation. The judge responds calmly but firmly, explaining that all rulings are lawful and that the motion he filed has been granted. The tension begins to shift from confrontation to acceptance.
No, you'll hear me. I'm going to tell you right now, I expect people to conduct themselves in certain ways in my courtroom. I don't know. Just listen to me. I don't want this, this other stuff in terms of comments that I'm making. I will show you respect, but the one thing I will not let happen, ever, you can sit up there and you can disrespect me all you want, but I will never let this institution in this courtroom be disrespected. So I'd suggest that you watch after I say something, what comes out of your mouth, because whether or not you're intending to give that impression, you certainly are to this court giving that impression. And if you continue to do that, and you've done it 2 or 3 times today, and I let it slide, but if you continue to do that, you're going to feel the full wrath of this robe come down on you, and I don't want to do that. Am I understood?
The judge addresses the misconception about needing to respond to every statement. Mr. Martin's persistence is met with clear legal reasoning. Discovery is granted. The trial is set, and further commentary about the facts is reserved for the trial itself. The courtroom dynamic reflects a struggle between individual will and procedural law.
Good.
Yes, Your Honor.
Thank you.
Supposed to spend the night with him, and I was supposed to pick them up that morning.
No.
That's why I was there.
So you're saying there was not a CPS safety plan in
Oh,
place?
yes, there is. Mhm.
All right.
And the plan that me and Jacob had came up with was for his dad to be on the plan and my mom to be on the plan.
Please watch. I just want to just guide you.
No. I want to listen to what she's saying because she's changing her story to me.
What, well, may I have a minute?
No,
Thank you.
she's on the witness stand. So go for it.
But anyways, I'm very remorseful for what happened that day.
No. Let's go back to the safety plan business.
Yes,
So you're saying there was an agreement with the safety plan for what?
just for my mom and his dad to be on the safety plan. That's it. That's all I was gonna say.
No, your mom just testified. You heard her testify that says she was not considered for the safety plan. So she was not on a safety plan.
Coming anytime soon.
As the session concludes, the judge reiterates the order, ensuring Mr. Martin understands the next steps. Jury trial notice and discovery documents will be sent in the mail. The courtroom settles, but the tension lingers, a reminder of how high stakes, procedure, and personal belief.
How does it not sound like payment's coming anytime soon when I just gave you guys $1,600? Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And this was and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's not,
anyone.
no,
You guys
it's
are
not
talking
going to
down as
happen.
if I'm a
It's
slob.
not going to, you want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor. That wasn't my attempt.
Response from Judge G.
You will get a fair trial that is guaranteed by the Constitution. No one here acts fraudulently. Every step we take ensures your rights are protected and justice will be done.
And I'm going to tell you, lying to me is a problem. This is the response about the tether. And don't tell me your DOC agent took your tether off, because what I'm about to read to you, your DOC agent did not do. Good afternoon. It was retrieved by one of our agents who located the device out in the field on November 30th. I believe near the location of removal. I did have a cut strap and the charger was not located. So tell me again how your DOC agent cut your tether off of you and threw it in the field.
When I got off Google, October 13th.
The tether was removed on or about November 28th, the day you missed court. Mr. Ray, tell me another story.
I cut the tether off.
Yeah, you cut the tether off.
You've had 3 motions to revoke in this court. So, and I know that each time you came before me, I've told you that you're.
As the hearing concludes, the judge sets pretrial dates and motions deadlines. The defendant continues to protest, but the courtroom procedures are clear and unyielding.